to the nation's highest court in the land today, making news for the work it did not do. A slew of decisions still pending on some of the biggest questions and issues facing our country. Things like abortion and guns to legal accountability for the January 6th insurrection. And of course, the question looming over a presidential election, a question with the power to make or break our very democracy. Is Donald Trump immune from prosecution for crimes he committed while serving as our president? In other words, American presidents, now kings. The federal election case brought by special counsel Jack Smith has been on hold for more than 6 months now. That in itself a victory for Trump, as he uses every lever of the justice system available to any criminal defendant to his advantage, with a single goal: to avoid standing trial before the election in November, at which point, if he prevails and is elected, he can dismiss the felony counts he faces for attempting a coup. As we have pointed out on this program before, every day that goes by without a decision one way or the other from the Supreme Court is a victory for Trump. It's a day that Trump gets closer to his goal. It's a glaring delay for many other reasons as well. There's the fact that not one but 2 of the 9 justices are facing calls for recusal. One whose home flew a flag that was also flown by the January 6th insurrectionists at the Capitol on his property. The other has a wife who was actively involved in urging state legislatures to overturn Joe Biden's victory and change the election result. There's the facts at hand in the case itself, the legal questions. As an op-ed in the New York Times points out, quote, Trump's lawyers put together a set of arguments that are so outlandish they shouldn't take much time to dispatch. Among them is the upside-down claim that because the Constitution specifies that an officer who is convicted in an impeachment proceeding may subsequently face a criminal trial, the Constitution actually requires an impeachment conviction before there is any criminal punishment. That gets things backward. The Constitution confirms that impeachment is not a prerequisite to criminal prosecution. And yet Trump's lawyers continue to take the untenable position in response to questioning that a president who orders the assassination of a political rival could not face criminal charges absent impeachment by the House and conviction in the Senate. It does not take weeks to explain why these arguments are wrong. We also know that the court is entirely capable of moving quickly if and when they want to. In the other big case involving the ex-president and the election this year, on the question of whether Trump could be on the ballot at all because of a clause in the 14th Amendment that bans insurrectionists from holding office, the Supreme Court was super speedy. It delivered a decision just 2 months after Trump's appeal to the Supreme Court. The New York Times reports this as well, quote, in addition to the disqualification case, 2.5 years ago, the court scheduled a challenge to the Biden administration's test or vaccinate policy 2 weeks after the justices decide to hear it, and then issued a decision invalidating the policy less than a week later. Add to that the fact that the court heard just 61 cases this term. That's what the Wall Street Journal says is, quote, close to a historic low. So a pattern exists, has emerged. Speed, something they're capable of, something they've done very recently. It's a priority for them if and when it benefits Donald Trump and his MAGA movement. Supreme Court tipping the scales in favor of Donald Trump is where we begin today. Senior editor for Slate, host of the Amicus podcast, Dahlia Lithwick, is back with us. Plus, voting rights attorney, founder of the site Democracy Docket, Marc Elias, is here. Our friend Andrew Weissman will join us in a couple of minutes. Dahlia, tell me if we're asking the right questions. Why do we think they'll be done on a normal schedule at all? I mean, are we sure that we're looking at the right chunk of the schedule? Could this go into July or August?
I mean, I think it's fair to say that they are on target-ish to be done either next Friday, a week from tomorrow, which is formally when they're supposed to be done, or to maybe bleed into a little bit that first week of July, which has historically happened when they can't get to all their cases at the end of June. The notion that the Chief Justice might let this kind of lurch on into August, I think, is probably beyond belief. But I think that it's really important to understand that even though there's only 19 remaining cases, you could sort of reach into the bag and pick any 3 of them, and they would be the biggest case of the term. This is such an incredibly drama-heavy docket that, you know, when you've got guns and the EPA and abortion and, you know, January 6th and immunity and content moderation, it's all there. And so, of course, they're having a hard time getting it all done. They bit off way more than they could chew when they took all these cases in the first place.
I mean, Dahlia, they've made fools of anyone who thought that they would see the national interest in deciding presidential immunity in a timely manner. Any visibility into where that is? Is it done? Is it written? Are they sitting on it? Are they briefing stakeholders? I mean, what do we know anything about that decision?
I don't know anything, and I haven't heard anyone who has asserted that they know anything. I think it's certainly possible that we have a dissent or an opinion that's taking an awfully long time to write. And again, the Chief Justice, you know, we always have to say, he can't put anyone in the naughty boy chair. He can't say to anybody, you know, turn in your work on time. In some sense, we are all at the mercy of the person who wants to run out the clock in this case.
Marc Elias, what Dahlia describes exacerbates an existing problem, and it's not the media coverage of the court. It is the way the court functions and the way the court seems to relish the public's perception of it as lacking ethics, lacking transparency, and being a willing partisan player. What do you make of what's coming down? I mean, what's ahead of them seems, if you wanted to orchestrate a final 2, 3, I'll be amazed if it ends in sort of a normal, timely way. If you wanted to orchestrate something to give the public the perception that you're putting your finger on the scale politically, this is exactly what you would do.
Yeah, I don't know how you could say that they didn't put their finger on the scale politically with respect to the immunity case. I mean, let's just start at the beginning. There was an immunity ruling against Donald Trump that went to the D.C. Circuit. The D.C. Circuit affirmed it and wrote a very thoughtful opinion. And at that point, the Supreme Court didn't have to take the case. As you point out, the Supreme Court only took 61 cases this term, which is not just a historic low, it is an abnormally low number for the U.S. Supreme Court to hear. Then they took the case, and rather than schedule it for immediate argument, they scheduled it for a late argument. Then now, obviously, they have not ruled on it quickly. They have effectively conferred an immunity by delay on Donald Trump. He has gotten the immunity he sought. Let's be clear. There is nothing in the Constitution that gives presidents immunity. In fact, quite to the contrary, the text of the Constitution suggests presidents don't have immunity, since the legislative branch does explicitly have immunity that is not shared with the executive branch. But at least some members of the Supreme Court, by manipulating the calendar, by simply deciding to hear a case they didn't have to, and then sitting on how quickly that case got decided, they have granted Donald Trump the relief he sought, which is that there will be no trial before the November election. And that is a tragedy for democracy. It is a thumb on the scale. And frankly, it does nothing other than undermine people's confidence in the U.S. Supreme Court as neutral arbiters.
Former Attorney General Eric Holder had some thoughts along the same lines. Marc Elias, let me show you what he had to say on this program yesterday.
It's hard for me to understand why the court even took this case. I'm worried when Justice Kavanaugh says things like, we have to write for the ages. No, you don't. You need to decide the case just in front of you on the basis of the facts and the law that has been presented to you. And if you do that, you'll reach the same conclusion as the appellate court, that a president needs to be held accountable in the same way that any other American would be. Any result other than that is I think, both absurd and extremely, extremely dangerous. You
know, Marc, the court seems to have made a bet that people are either too stupid to figure this out, that because there aren't cameras in there, we won't know what's said and what's done. But I think of all the issues that voters intuit, with and without consuming mountains and mountains of news, is that there's something very wrong at the Supreme Court. And its decisions on abortion and potentially on this one as well are way out of the mainstream of sort of a right-left debate in the country. What are the stakes for the court as they get ready to release whatever decision they've made on immunity?
Yeah, I think it is not just that they're outside the mainstream, but they seem unmoored. There have always been a range of positions and ways of interpreting the Constitution. You have had more progressive views of how you interpret the Constitution articulated by justices like former Justice Breyer, former Justice Ginsburg, and you've had more conservative ways of interpreting the Constitution, originalism and textualism being probably the two dominant conservative theories. But in recent years, and particularly in some of the arguments this term, and the immunity argument is a good example, we are kind of going into the vibism phase in which the conservative justices are just listening to the cases and sort of getting a vibe for whether or not it accords with what they would like the outcome to be or not. Not what the text says, not what the founders originally said. I mean, the founders originally had no concept of giving presidents immunity. There is nothing in the text of the Constitution that gives them immunity. In the Dobbs decision, they discarded what several of them in their confirmation hearings said were super precedent or precedent upon precedent. Stare decisis, one of the most important principles of the law, got sort of thrown away like a used tissue. So it is the unmoored nature of the decision making as much as anything else that I think is causing a crisis in confidence in the Supreme Court. And make no mistake, when the Supreme Court has a crisis of confidence, it is no one's fault but their own. The Chief Justice ended last term with a very stinging opinion in which he said, basically people have to stop criticizing us so much because the courts need to have their integrity. And, that integrity is earned. It is not something that is dictated. And if the Supreme Court is losing the public confidence or the confidence of some of the justices, they need to look inward, not outward.